Hi, welcome to the conclusive episode of Fredrick M.Kunda versus the People, Appeal number 37 of 2020. So, in this case, I tried to basically go into a bit more detail as to how the Supreme Court decided in vacating the conviction that was granted by the Subordinate Court and why they let the applicant go, based on the fact that section 122 that was used by the magistrate court was non-applicable in this matter. So I'll go directly into it to be a bit technical, so forgive me. So what you must understand is the Constitution, which is the supreme law of the land, creates all the courts in Zambia. That is where they derive their powers from. And it is also this Constitution that provides for how an act of parliament is to be enacted. So the act of parliament provides for the powers, for the functions of these specific organizations and institutions, which include our courts. And those acts of parliament are basically telling us what the courts can actually do and how they are supposed to do it. Now, in the case of the Development Bank of Zambia, who are the respondents? I'm just taking this one off my head. JCN Holdings, the Post Newspaper, and Intembo Nchito. The Supreme Court spoke to the aspect of following procedure as outlined in our rules of the court. In this case, they were saying the manner in how Judge Wood was replaced by Judge Mutuna to hear the matter and give judgment was not followed. And because that cycle was not properly followed, the matter had to be reheard again because Mr. Mutuna had no actual power to hear the matter because the rules were not followed as expected. So, with that frame of mind, with that aspect in mind, what I'm basically trying to say is, in our country, when we are trying matters, civil or criminal, we must adhere to the procedural code that has been outlaid. Whether it's criminal or civil, a judge must come to a conclusion based on following each and every expected criminal or civil procedure. And if they do fail, people will go on appeal and argue to say that the matter was not properly heard or that the judgment is defective on the basis that this did not occur. And that is why I said, to a specific end, if you are a jurisprudence scholar, you could argue Fredrick M.Kunda versus the People shows us that justice and the law are two separate ideologies and that the law does not mix justice. The law is that which is and not that which ought to be. And as such, if the law says this, you cannot change it. And that when the law has been enacted, that law is a law that must be applied. And if you do not apply that law as a judge or as a subordinate magistrate, you will be seen to have acted out of bias, or your action will be cancelled because you didn't apply the correct law. Now, in this instant case, the subordinate court or the magistrate applied law that was now ineffective. So the Supreme Court is now saying you can't apply law that is ineffective when there is actual law. So if you apply law that is ineffective, your judgment on that aspect will have to be thrown out because you are citing statements that are not there, and you are required to always ensure that you are citing correct criminal procedural laws. So when we get back, we will look at the section 122 that was cited by the subordinate, by the magistrate, and the new section 122, and also the aspect of a witness as a child. For now, some Ben sound. So, okay, welcome back. So, when it comes to the law, a repealed act, once it has been substituted, is no longer enforceable in the courts of law. Meaning, even the judges cannot enforce laws that are no longer applicable because they must adhere to the rules of the law. So everyone is above the law. So in this instant case, the judge was citing the old section 122 of the Juveniles Act Chapter 53, which required him only to identify whether the child knew the nature of an oath, and if they understood that, then they clearly possess the intelligence and understanding of speaking the truth, and they can be a witness. But however, the law in this aspect was actually amended on 12th April 2011 under the Juveniles Act, Amendment number 3 of 2011. Now, under the new provision which substituted the old, anyone below the age of 14 who is a tender child or child of tender age had to give evidence on oath if the judge is of the opinion that this child is possessed or possesses sufficient intelligence to justify the reception of the evidence and understands the duty of speaking the truth. Now, the process that has to be undertaken in this instance for a child to be a witness is what is known as a voir dire. Now, in a nutshell, a voir dire is us saying a child is competent and compellable enough to be a witness in a criminal or a civil matter because they understand the duties of speaking the truth and they can speak the truth without being swayed, because children are easily deceived, or you can basically lie to a child. So, and they understand what the case is about and the facts, and they can easily talk about it. And they possess sufficient intelligence because they have to be cross-examined. And you know cross-examination is difficult. So, in this instant case, the Supreme Court said the trial judge or the magistrate was applying law that was ineffective. He was not supposed to look at whether the child understood the nature of the offense, but he was supposed to determine that. Let me quote from the judgment of the Supreme Court in this aspect. Just hold on a bit. So, this is what the Supreme Court had to say. Okay. So, Section 1.2 of the Juveniles Act, the trial court had first to establish whether the child was possessed of sufficient intelligence to justify the reception of her evidence on oath and whether she understood the duty of speaking the truth. This is the first part, and once the child gives evidence, a trial court must not convict unless the child's evidence is corroborated by other material evidence. However, in this case, the trial court asked the child whether she knew the meaning of an oath, which was a requirement under the repealed Section 122. So the trial judge was asking her the meaning of an oath, which is now under the repealed Act. Section 122 is a very long act under the Juveniles Act, so I'm not going to cite it. I've just summarized it because people get tired when I'm just reading. So at the end of the day, the court had to vacate that conviction because it was not safe to convict. Because when they removed that evidence, there was no other evidence that was supporting the allegations that were made. Let me again quote from what the Supreme Court said. Alright? So they said, the question is, where does this leave the prosecution's case? Is there any evidence to prove that it is the applicant who defiled the child? Can the conviction stand? The answer is no. The record shows that apart from the mother who was told by the child that the applicant defiled her, there is no other evidence to connect him to the offense. What this brings about is the standard that when it comes to criminal law, the evidence of the prosecution is what will lead the trial court, the subordinate court, and the high court to basically convict any person and that there must be evidence that must link the person who is accused. Collaboration, supporting independent, clear evidence. And in sexual offenses, there has to be now also supportive evidence that will link the person accused. So meaning the aspect of identification is important. Of course, the medical examination was there, but the Supreme Court felt there was nothing else that could connect the prosecution's case against the applicant. And they stated that the fact that the applicant was a cousin to the child and he had an opportunity to commit the offense, while it was not disputed the applicant was a cousin to the child, this relationship was not proof that he is the one who defiled her. So meaning, or he had an opportunity, meaning you have to remove all doubt and show the court that this person is a person who committed this offense, whether it's a sexual offense or anything. So at the end of it all, I just wanted to explain in detail, maybe for those that didn't understand the judgment and how we discussed this in the first episode because of due to time. So thank you for listening to this podcast. It's been a dark podcast, I think, this one for me. I'm also saddened by the turn of events. But the law is that which is the law. And I'm now speaking in jurisprudence. So there is the knowledge of the law, which you call jurisprudence, which every lawyer has to take and which most lawyers hate, or they will tell you they don't like it. But the definition of the law is there's no real definition of the law. Okay? So the law is seen in many spectrums. Now in this instance, you could argue to say there are two schools of law here. One, the positivists, who believe that the law is that which is written and that which ought to be obeyed. And because the law was amended, what was removed from the law has no longer got any legal force. That's one. Two, the belief is that it is not until the judge has passed a judgment or the Supreme Court has made a ruling will it become law. You could argue that. Because in this instance, you've seen the other judge cited the old provision, but the Supreme Court said, no, you don't cite these provisions. So you could argue it from that aspect, but I think the second one is a weak argument as compared to the first one. So thank you for listening to the podcast. I hope you have been informed on the aspects of criminal procedure when it comes to evidence of a child, that there is a process that has to be taken, that a child cannot be just called a witness. They do not qualify, or they are not allowed to be witnesses. There are exemptions to the general rule under the aspect of criminal procedure when it comes to evidence, and there's a manner in how we determine whether or not a child can be a witness in any trial case, and that the Juveniles Act, Section 122, as amended, guides us on how to do that, and that is applicable law that should be followed, and not Section 122 of the now repealed Juveniles Act. Hopefully you've understood, and thank you very much. Hopefully to see you some other time. So we'll put out content maybe next week or some other week, but we'll still be putting out content. Would also like to hear from you. Is there any cases that you would want us to talk about, or areas of the law that you want us to talk about? So this is me signing out. My name is George Tintan from Manipilo, and have a fantastic new week. Remember, COVID-19 is still real. Wear a mask, follow the regulations, and we love you. 2020 has been a dark year, but at the end of the day, we want you to survive. So thank you very much, and hope you enjoyed the podcast. I am signing out. Bye.